which have come under the BNS vis-a-vis the CRPC. We thought, why not call a speaker, a judge whose judgments are appreciated when she was adorning the bench and even thereafter. I also saw a lot of WhatsApp coming as to once Justice Mukta Gupta, a former judge from Delhi High Court, and now a senior advocate in Supreme Court of India is coming. I can say that the social media was abuzz with that she's coming, and the fact that the Zoom meeting is also full shows volume of popularity of the knowledge of Justice Mukta Gupta. So today's session is CRPC versus BNS, changes in the new criminal procedure code, and we are glad that Justice Mukta Gupta has accepted our invite. And thank you, ma'am, for accepting our invite, and over to you.
Thank you, Mr. Chatrat, and thank you everybody for waiting for so long. Good evening, everyone. The 3 new criminal laws have now come into force on the 1st July 2024, and that is the law. Every law is an embodiment of the societal demand, and law evolves with the society. The legislature has done its job. Now it will be left to the courts to interpret it and the executive to implement it. Like any other law, even this is a baggage where there are some very good steps taken and some provisions which may need some pronouncements from the court or amendments in the long run. Some of those provisions which have been amended and which have been newly added, I would like to bring to everybody's notice today. In the Bharatiya Nagrik Suraksha Sanhita, which is now in short called BNSS. Now, as per section 3 and 6 of BNSS, earlier in the metropolitan cities, we had metropolitan magistrate and the judicial magistrates in the states. Uniformly all through, it will be only judicial magistrates. And they have abolished, and the Act has abolished the post of metropolitan magistrate or judicial magistrate 3rd class, as also assistant session judge. With the result, there are 4 categories of judges: the judicial magistrate 1st, 2nd class, 1st class, including chief judicial magistrate, and the session judge, including additional session judge, and the executive magistrate. Consequent amendment have been brought in the corresponding provisions. By and large, you will see that the provisions of BNSS are almost the same as CRPC, only the numberings have changed. And wherever you will find that the provision is parameteria the same, obviously the old precedents and judgments will apply because the language has not changed. Now, under section 23 BNSS, the only modification which has been done, amendment which has been done, is that though the CJM continues to have the power to give prescribed punishment to 7 years, judicial magistrate 1st class up to 3 years, and judicial magistrate 2nd class up to 1 year, the fine imposed by them is increased from 10,000 to 15,000 and from 5,000 to 10,000. Further, section 6 of the Bharatiya Nyaya Sanhita, that is BNS, which comes in place of Indian Penal Code, prescribes community service as an alternate mode of sentencing. Now, all category of judges, including the magistrates, have been empowered to impose community service. Community service has not been defined in the Bharatiya Nyaya Sanhita, BNS, but in BNSS, in section 23, the explanation states that it is the court, it's explained as a court-ordered work that benefits the community, which is not entitled to any remuneration. ये explanation to section 23 के तहत add कर दिया गया है. But the problem which arises is, if you read BNS, all provisions provide either sentence or fine or sentence and imprisonment. So it is not clear And community service has not been provided as an alternate either to the fine or to the sentence. So where community can be service can be substituted will have to evolve over the period of time. Earlier, under Section 31 CRPC, considering the gravity of several offences, the court could direct punishments to run concurrently. Now, earlier it was that the cumulative sentence should not exceed 14 years. Like supposing a person is involved in 5-6 different offences in one transaction, the court could say that the sentences will run concurrently in view of the gravity of offences. But now that has been enhanced to cumulative sentence should not exceed to 20 years. There was a lot of hue and cry for non-monitoring of the prosecution, especially at the level of the districts. So Section 20 BNSS now provides Directorate of Prosecution even at the district level. So whereas the hierarchy has been created of a director, assistant director and deputy directors with work divided amongst them to monitor cases punishable up to 10 years or more, 7 years or more, and then less than 7 years. Section 35(7) BNSS provides that no arrest shall be made in case an offence is punishable in less than 3 years. This is a new provision. And if the person is infirm or above the age of 60 years without prior permission of officer not below the rank of DS. Now, Section 63 BNSS introduces service of summons through electronic mode. So now summons can be authenticated by the image of the seal of the court or digital signatures, and under Section 70, service can be effected through electronic means. Now, for that purpose, Section 64 directs that registers will be maintained at the police station or in the court to keep the address, email address, phone number, etc. of the persons to be summoned. So in future, I think rules will have to be framed or a common consensus will require to be arrived at between the courts and the police stations where it will be. Earlier, summons could be effected on a person only through an adult male member of the family. But now this provision has been made gender neutral under Section 66 BNSS, wherein summons can be effected on any adult member of the family. Section 82 BNSS casts a duty on the police officer making arrest to forthwith give information regarding such arrest and the place where person arrested is being held to the designated police officer. Like, for example, if the arrest is made by another police station or a police officer of another police station, he must immediately inform about that arrest. Further, there are changes. There is some amendment in Section 84 BNSS, wherein earlier person could be declared a proclaimed offender. The proclaimed offender could be for certain category of offences like murder, culpable homicide, dacoity, etc. Now, if an offence is punishable with 10 years or more, for those offences, a person who is not traceable or who could not be found out after following the due process can be declared a proclaimed offender. Under the CRPC, the dependent father, mother, wife, and children could seek maintenance under Section 125 CRPC, which is now 145 BNSS. The change which has been brought is that the dependent parents can now initiate proceedings at their place of residence. So wherever they reside, they can file the petition seeking maintenance, and they do not have to go to the place where the child from whom they seek maintenance is residing. There are some new provisions which have been added in the BNSS. Firstly, it is section 43(3) BNSS, which gives the power to the police to use handcuffs while making arrest, keeping in view the nature and gravity of offense. And this will be applicable to if the accused are habitual offenders, one who has escaped custody, one who has committed an offense of organized crime, terrorist act, drug-related crime, possession of arms and ammunition, murder, rape, POXO, offense against the state. Now, there is some, I would say this provision may be prone to scrutiny by the courts for the reason Supreme Court in the decision in Prem Shankar Shukla versus Delhi administration earlier held that categorizing or giving the power to put handcuffs based on the nature of and gravity of offense was violative of Article 21 of the Constitution of the Constitution of India. So this the ground given being nature and gravity of offense may not be the appropriate criteria in terms of the Supreme Court decision. And secondly, to my mind, it also affects the basic right of presumption of innocence till convicted in a case, particularly when the accused is not escaping or is easily available merely because he is alleged to have been involved in particular category of cases may not be appropriate to use the handcuffs. Then there is a very useful provision which has been added, which is section 105, which provides that the search and seizure now will have to be carried out through audio video electronic mode, and which will be preferably the mobile phone of the police officer. And this recording has to be immediately forwarded to the district magistrate, SDM, or the judicial magistrate first class without any. Now, as far as Delhi is concerned, I think e-Praman app has been made. So whatever is recorded will be uploaded on that app, and as per the police, there can be no tampering with it. But however, as we progress, we'll see what are the pros and cons and any issues with regard to the admissibility of the evidence in this regard which crop up. But undoubtedly, an audio video electronic mode of recording the search and seizure should prove to be fruitful. Section 80-83 CRPC, which permitted attachment of the property of an accused who had been proclaimed as an offender, now stands expanded by section 86 BNSS, which provides that even if that property of that accused is in a contracting state, that is a state outside India where India has a contract, so that property can also be attached. And in this regard, a written request of a senior police officer not below the rank of SP or CP, that request can be made, and the court will pass necessary orders. May pass necessary orders thereon. Further, section 107 BNSS provides for attachment, forfeiture, and restoration of the property derived, obtained, directly or indirectly as a result of criminal activity. This is something like the proceeds of the crime, and any property derived or obtained directly or indirectly from a criminal activity is liable to be attached, and an application in this regard will be made before the court concerned, and after hearing the affected party, the court may pass orders even before the trial concludes or after the trial concludes. And if there is some exigency, an ex parte ad interim order can also. A new provision, section 172 of BNSS, has been added, which mandates all persons to be bound to conform to the lawful directions of the police officer given by him in fulfillment of his duties under chapter 12, which provides for, like we had 107 CRPC and all, prevention of cognizable offense or arrest to prevent cognizable offense. It is said that if the person does not obey, the police officer may arrest and may even produce before the court magistrate concerned. We all know section 154 CRPC provided for registration of it. Section 154 CRPC is now 173 BNSS. However, in section 154(1) CRPC, a phrase has been added which is irrespective of the area where the offense has been committed. Thereby, an FIR can be registered even at a police station where the offense has, under whose jurisdiction the offense has not been committed. The fact that the police which registers FIR irrespective of whether the offense was committed in its jurisdiction can proceed to investigate and even arrest is fortified by the following provisions, and particularly section 183 BNSS, which mandates that the judicial magistrate of the area where the offense is registered can record the confessions and statements. Now, section 173 also permits, subsection 3 also permits that the police may carry out a preliminary inquiry before registration of FIR for an offense which is punishable from 3 years but less than 7 years, subject to the permission from the DSP/ACP. Now, the scope of inquiry, preliminary inquiry, as provided under Lalita Kumari, was whether the complaint discloses the commission of a cognizable offense. However, in this, the scope is whether a prima facie case is made out or not. So the police can inquire and thereafter proceed with registration of FIR. Now, section 173(4) also has a phrase added therein, which was not there in section 154, subsection 4, which says making an application to the magistrate. So, in case FIR is not registered, you proceed to make an application to the senior officer, and even then, if an FIR is not registered, an application can be made to the magistrate. Now, here there is no, it is not prescribed whether the magistrate has to be the magistrate where the offense took place or where the application for where the complaint was filed for registration of FIR, under whose jurisdiction the complaint was filed for registration of it. Under section 175(3) BNSS, which is akin to section 156(3) CRPC, before an investigation is directed by a magistrate in a cognizable offense, the magistrate is now required to examine the application of the complainant along with the affidavit, as also seek a report from the police. So before registration of FIR, not only in terms of Priyanka Srivastav's judgment, the complaint should be accompanied by an affidavit. A report will also be called from the magistrate, from the concerned police station. Further, under 175(4), a further protection has been granted to public servants in discharge of their duty to avoid them facing false and frivolous prosecutions. So before magistrate takes cognizance of a complaint against a public servant in discharge of his duty, it is necessary to hear the public servant. Now, to bring credibility to investigation, forensic experts have been mandated to visit the crime scene to collect forensic evidence in all cases where the offense relates to punishment which is punishable for 7 years or more under section 176(3) CRPC. This would be a very positive step for the reason if forensic evidence is collected by the forensic team from the scene of crime immediately and preserved and analysis done, I think the scientific evidence which we find due to putrefaction of samples later on will be avoided. Now, state governments have been directed to have their forensic labs within 5 years. Until they do not have, they need to take help from the adjoining states. Now, under protection has also been granted to the victims of rape, wherein their statements will be recorded by a lady judicial magistrate, in the absence thereof by the presence of a lady, and this will be audio, and the statement which is recorded by the police will be audio videographed. Further, in heinous offences which are punishable for 10 years or more, police is mandated to record the statement of main witnesses before the judicial magistrate under section 164 CRPC, which would, I think, be a very positive step, in the sense, once magistrate records a statement of the witness, there will be more credibility attached to it. Further, the registered medical practitioners have been mandated to forward the report of examination of a victim of rape within 7 days to the court concerned, to the magistrate under section 184(6). We've all seen that the medical reports would take a lot of time to come to the court. They were causing delays. Checks have also been provided on the powers of the police while conducting search under section 185 CRPC. So firstly, the police officer is required to record the grounds of his belief for conducting search at a place in the case diary under section 185(1). Further, such search, as I said, has to be audio videographed by electronic means. And then under 185(5), the police officer is made accountable to send the copies of that recording to the nearest magistrate, empowered to take cognizance within 48 hours. Now, initially under the CRPC, the provision was under section 167(2), 167 that only for the first 15 days of arrest could the police custody be granted. There is an amendment, and now section 187 provides that the total of 15 days of custody can be provided piecemeal or in one go in first 40 days, where the charge sheet is required to be filed in 60 days, and in the first 60 days, where the charge sheet is required to be filed in the first 90 days. So it is not that once the first 15 days period is over, the police cannot take the police remand. It may be that it initially takes 2 days remand, then sent to judicial custody, and then again call for the police remand in cases where like some more evidence is collected, other co-accused is arrested for confrontation. But the provision also says that this police custody will be granted only if the accused is not on bail or his bail has been cancelled. There is a further protection provided under proviso to section 480 BNSS that the accused being required for police custody beyond the first 15 days will not be the sole ground for refusing grant of bail to the accused. But we all know it may not be the sole ground, but it will be one of the main grounds for it. Earlier, some of the police officers, even if the accused was not arrested during investigation, would insist on the arrest of the accused to be produced in custody when the charge sheet was filed. We had Supreme Court judgments which said that there was no requirement, which is now incorporated under the proviso to section 190 BNSS, which says that if the accused is not in custody, the police officer shall take security for appearance before the magistrate, and the magistrate shall not refuse to accept the charge sheet on the ground that the accused is not taken in custody. A step towards being the criminal law being more victim centric. Section 193(3) subsection 2 mandates the police officer to inform the progress of investigation to the informant or the victim within 90 days of investigation carried out. Earlier, it was that the victim was always kept in the dark as to whether what happened in the investigation, whether the accused was arrested, charge sheet filed or not. Now, within 90 days, intimation is required to be given, and the same can be given even by electronic. Section 193(2) provides that in certain cases like of POCSO or rape, though the period when charge sheet can be filed will be 90 days, but the investigation must be completed within 2 months. Now, there being no consequence provided thereto, this provision will not be mandatory, because if it had said that in case it is not filed in 2 months, the accused is liable for default bail, that may be a different consideration, but it is not provided. So it is a direction given that the charge sheets in such cases should be expedited and preferably within 2 months. Earlier, when the charge sheet was filed as usual, it would always be written that in case further evidence comes forthwith, further investigation will be carried out and supplementary charge. Now, under section 193(9) BNSS, it has been provided that once the charge sheet is filed, further investigation, if any, by the police should be completed within 90 days. And if they have to carry out any investigation beyond that 90 days, further 90 days, they must seek the prior permission of the court concerned. The provisions where the trial can take place, which were earlier provided under section 177 to 184 of the CRPC, are verbatim the same under sections 197 to 204 BNSS. So even if an FIR is registered in another jurisdiction, investigated there, the trial will be as is in terms of section 197 to 204 BNSS, which are akin to section 177 to 184 C. As far as supply of copies is concerned, it is now held that even supply of documents should be done within 10 days of within 14 days of the appearance of the accused, and supply of documents electronically is also sufficient. In the CRPC, if a complaint case was filed, the complainant was examined, his witnesses were examined, and the magistrate, on the basis thereof, proceeded to take cognizance of the offence. Now, in terms of section 223 of the BNSS, before taking cognizance and after recording of the statement of the complainant and its witnesses, the magistrate is bound to give an opportunity to the accused person to present his side of the case, and only thereafter cognizance will be taken. Further, if the proposed accused is a public servant, then not only before taking cognizance, the public servant will be heard, but a report will also be called regarding the facts and circumstances of the incident from his superior officers. Earlier in CRPC, only the document, the person who has prepared the document would appear in the witness box and depose about it. Now, section 336 BNSS provides that if a document is to be proved and the public servant, expert, police officer, or investigating officer has been transferred, retired, died, or cannot be found, or incapable of giving deposition, another or his successor police officer, expert, scientific officer, medical officer can be deputed to give deposition. However, this will be only if the accused disputes the said document. So the document will be deemed to be admitted unless the accused disputes the same, and the successor or any other officer will come in case the person who's prepared the document is not available. Of course, there will be issues arising, and we may have petitions on this regard before the court. Under the CRPC, under section 299, if an accused absconded and was declared a proclaimed offender, his trial was separated, and trial for the other accused would proceed. Now, under section 356 BNSS, if it is found that the accused person has been declared proclaimed offender and he has absconded to evade the trial, then the court may, after recording reasons, proceed with the trial as if the accused is present and pronounce a judgment. So the court can go ahead to pronounce the judgment of conviction as well. And it is further provided that in case such an appeal is filed, an appeal against such conviction is filed, the same will not be entertained unless the accused surrenders. Timelines have been provided for the courts to deliver the judgments, and Section 258 BNSS provides that within 30 days of hearing the conclusion of the arguments, the judgment is required to be pronounced by the court, and the same can be extended to 45 days with reasons to be recorded in writing. And Section 392 also provides that within 7 days of pronouncing the judgment, its copy should be uploaded on the portal, making the system more transparent. Now, Section 293 CRPC, BNSS, which provides for plea bargaining, also has a rehabilitative approach. So in a case where there is a minimum sentence prescribed and it is a first-time offender, the plea bargaining provision provided for a norm of 1/2 of the minimum sentence, which has now been reduced to 1/4 of the minimum sentence. And where no minimum sentence is prescribed, the quantum has been reduced from 1/4 of the maximum to 1/6 of the prescribed punishment. There is one more amendment which gives hearing to the victim and is a victim-centric approach. Earlier, the prosecutions were withdrawn on an application filed by the PP under Section 321 CRPC, and the victim had no say. Now, once an application is filed for withdrawal of the prosecution, the magistrate will have to give an opportunity to the victims or complainant to place his facts, and only after hearing the complainant victim will an order be passed on this. Now, by this BNSS under Section 392 CRPC, the state governments have been mandated to formulate witness protection schemes, and once these schemes come into force, I'm sure they will all be very useful to the witnesses. There is also an amendment to the provisions of sanction which were there under Section 197 CRPC, which is now Section 218 BNSS. Section 218 BNSS provides that if the competent authority does not grant sanction within 120 days, it will be deemed to have been granted. Now, this may have serious consequences on the accused public servant because it will forfeit its valuable right to challenge the sanction order on the ground of non-application of mind or by an incompetent authority. Type of sanction. So, like any other law, BNSS is also, though 90% same as the CRPC, but with some amendments, it is a baggage which has some advantages and some issues which over the time will be sorted out by various pronouncements and rendered by the courts. I'm sure, I think with this, there'll be a complete sum up of the entire BNSS, which I could have provided. And if there is something which is not understood, I can still explain in Hindi, but I thought I went with a very simple language and not the technical language of explaining it in English and not the technical ones.
Yeah. I think there could have been more simplified words for the explanation. There are right now only two questions. Let's see if other comes. Could you just elaborate more on zero FIR?
See, zero FIR earlier, section 154 did not specify whether the police station where offense has not been committed has the jurisdiction to register. The jurisdiction was for the trial. But now with the insertion of this particular place, irrespective of the area where the offense has been committed, and the subsequent sections and the subsequent subsections permitting investigation thereon, and there being no clarification that this can be done when there is only a conflict of two adjoining police stations who's to register FIR. Zero FIRs were mostly registered when there was a conflict between two adjoining police stations. But this, irrespective of the area where the offense is committed, is a very wide expression which gets into it. Coupled with the subsequent subsections of section 173 CRPC, as also 183, which mandates recording of confession by the magistrate where the FIR is registered. So the very recording of confession by that magistrate, confession will be recorded only if the accused is arrested. So in a way, it implies that the FIR can be registered anywhere, investigation carried out, arrest made. But yes, when it comes to the trial, it will be in terms of section 197 to 204 BNSS, which is akin to 197 to 184 CRPC. That is the court in whose jurisdiction the offense took place or the consequences thereto ensued, like in the case of kidnapping, where the kidnapping took place or the person kidnapped or abducted was traced, or in a case of cheating misappropriation where cheating took place or the money was recovered. So both had the jurisdiction. So the trials will be according to them.
Thank you. The illustration was so good. As we had discussed prior to going live, can you just sum it up in pure Hindi? What the terminology is exactly as such in Hindi? If you can sum up it in Hindi.
Sorry, I couldn't take the question, Mr. Vikas.
It's not a question. I'm saying, could you sum it up something in Hindi so that rather than English, I've understood that you've taken more on Hindi English, but if it can be summed up in 10-15 minutes, what are the key points from this new changes?
So some of the key points in this is, इसमें कुछ जो victims के लिए beneficial provisions आए हैं, वो ये आए हैं कि अगर prosecution withdraw करना होगा, पहले APP अपने आप कर लेता था, अब कोर्ट विक्टिम को भी सुनेगी. विक्टिम को 90 दिन के अंदर इन्वेस्टिगेशन क्या हुई है वो बताई जाएगी. उसके अलावा विक्टिम प्रोटेक्शंस, विटनेस प्रोटेक्शन स्कीम्स लाई जाएंगी. फोरेंसिक टीम्स स्पॉट पे जाके इन्वेस्टिगेशन करेंगी. प्लस जो विक्टिम के फेवर में है कि जो उनका मेडिकल है वो इमीडिएटली कोर्ट में जाएगा और कंप्लेंट पुलिस बताएगी क्या क्या किया हुआ है. सीन पे इन्वेस्टिगेशन होगा बाय द फोरेंसिक एक्सपर्ट ताकि इमीडिएट एविडेंस कलेक्ट हो जाए. ये सब प्रोविजंस विक्टिम के फेवर में है. नाउ टू मेक दूसरे प्रोविजंस जो कुछ ऐड करे गए हैं, जैसे कि इन्वेस्टिगेशन साइंटिफिक तरीके से हो, उसमें है कि सर्च और सीजर जब पुलिस करेगी तो ऑडियो वीडियोग्राफ करेगी, और वो 48 घंटे के अंदर अंदर मैजिस्ट्रेट जो कॉग्निजेंस ले सकता है ऑफेंस उसको भेजेगी। फिर जो ये समन्स हैं उनकी सर्विस उस पे हो जाएगी, ये इलेक्ट्रॉनिक मोड से हो जाएगी। प्लस पहले से ऐसे समन्स सिर्फ अडल्ट मेल मेंबर पे होता था, अब किसी भी अडल्ट मेंबर ऑफ द फैमिली पे समन सर्विस हो गए तो इट विल, वो माना जाएगा कि प्रॉपर सर्विस है। उसके अलावा कुछ प्रोविजंस जैसे कि पुलिस डायरी मेंटेन की जाएगी जिसमें रीजंस लिखे जाएंगे कि आपने सर्च एंड सीजर किस लिए की। अभी तो पुलिस जैसे उठ के आ जाती है सर्च एंड सीजर के लिए, कॉग्निजेबल ऑफेंस होता है तो वारंट्स की भी, कोर्ट वारंट्स की भी जरूरत नहीं होती है, तो वो ग्राउंड्स केस डायरी में होंगे। तो विद द रिजल्ट जब कोर्ट में केस जाएगा तो कोर्ट देख सकती है कि जब तुम सर्च करने गए तो तुम्हारे पास क्या ग्राउंड्स थे, और ये सब डॉक्यूमेंट्स इमीडिएटली कोर्ट के पास जाएंगी। दूसरा, अटैचमेंट ऑफ प्रॉपर्टी, जो एक्यूज्ड की, अगर एक्यूज्ड ने अटैच ऑफेंस करके कुछ प्रॉपर्टी डिराइव की है तो क्रिमिनल कोर्ट्स को पावर दी गई है कि वो प्रॉपर्टी अटैच करें, पर एक्यूज्ड को सुनने के बाद अटैच करें। ये सब प्रोविजन से थोड़ा सा इम्पीटस मिलेगा ताकि इन्वेस्टिगेशन और अच्छी तरह हो सके। कुछ प्रोविजंस जो रेट्रोगेट हैं, जो थोड़े से स्टेप बैक्स हैं, जैसे यूज ऑफ हैंडकफ्स, कि भाई सीरियस ऑफेंस है तो हैंडकफ्स होने चाहिए, भाई अगर एक्यूज नहीं भाग रहा तो हैंडकफ्स किस लिए होने चाहिए। और दूसरा, सुप्रीम कोर्ट ने स्पेशली जब कहा है कि ये कोई रीजन नहीं हो सकता हैंडकफ्स लगाने का। प्लस अटैचमेंट ऑफ प्रॉपर्टी ही लें, अगर कल को एक्यूज्ड एक्विटल हो गई है उसकी, उससे पहले अटैच होके फोरफीट होके अगर प्रॉपर्टी सेल हो जाती है, थर्ड पार्टी राइट्स क्रिएट हो गए, तो उस कॉन्सिक्वेंस में एक्यूज्ड के क्या राइट्स होंगे। ये सब थोड़े से इश्यूज हैं जो ओवर द टाइम आई थिंक जैसे जैसे मैटर्स आएंगे तो वी विल ऑल हैव टू डील विद इट। अब जो एक प्रोविजन आया है कि कंप्लेंट केसेस जब फाइल करेंगे तो कॉग्निजेंस से पहले एक्यूज को सुनेंगे, उसमें ये भी डिटरमिन करना होगा कि एक्यूज को कितनी राइट मिल सकती है। अब अगर उसी स्टेज पे उसको क्रॉस एग्जामिनेशन की राइट तो दी नहीं जा सकती है, एक लिमिटेड हियरिंग ही दी जा सकती है कि भाई कुछ ये एलिगेशंस बिल्कुल ही गलत है, कुछ मटेरियल वो दे सकता है जिससे कि वो टोटल डिस्प्रूव हो जाएगा। तो राइट ऑफ हियरिंग टू बी मीनिंगलेस हैज टू बी मीनिंग, मतलब माइंड कुछ उस राइट जो सुनवाई है वो मीनिंगफुल होनी चाहिए किसी को भी, चाहे वो एक्यूज्ड हो चाहे वो विक्टिम। तो वो किस एक्सटेंट तक जानी चाहिए उस स्टेज पे कॉग्निजेंस से पहले, ये सब इश्यूज अभी आई थिंक जो नई अमेंडमेंट से आए हैं इन सबको अभी डिटरमिन करना पड़ेगा।
शुक्रिया मैडम, आपने संक्षेप में बहुत अच्छा समझा दिया है। सब चेरिश करेंगे, इतनी जल्दी शायद कोई ना समझा सके। थैंक यू मैम फॉर शेयरिंग योर नॉलेज एंड अगेन
Thank you very much. It was a pleasure sharing with all of you, and of course I think it will benefit all the viewers who are there present, and I'm thankful for them to be patiently listening to me. Thank you very much.
Everybody has cherished. I can see on the YouTube that people have cherished this session. And tomorrow, friends, we have continuing with the understanding of the new 3 acts. Tomorrow it is Bharatiya Saksha Abhiniyam, BSA, a bird eye view, by Justice Ved Prakash Sharma, who's a resource person in the National Judicial Academy Bhopal, coupled with the fact that he's also a former judge from Madhya Pradesh. Do stay connected with us. Thank you, everyone. Stay safe, stay blessed.